Ever since it was decided that there should be the new acts, including the Bhartiya Sakshya Adhiniyam, BSA, we thought, why not request Justice Pradesh Sharma, a former judge, Madhya Pradesh High Court, and a chairperson, M.P Law Commission, to speak on this topic, because a lot of people want to understand these new topics as to whether there is any change or what are the challenges after the coming into being of this act. We requested Justice Pradesh Sharma, who has already done sessions on the Evidence Act, and his sessions, if one who watches or follows the Anomalies would see that they have been very well received. Therefore, we can say that he's an authority specifically under the Evidence Act. You can watch the previous sessions. This particular session will be divided into three particular parts, as we have discussed with Justice Pradesh Sharma. Now, I would request, sir, to take over the session. Over to you, sir.
Okay, thank you, Vikas ji, and good evening to all the persons who are connected virtually in this discussion session. Now, I'm supposed to discuss about the new Bhartiya Sakshya Adhiniyam 2023, which has been brought into force with effect from 1st of July 2024. Friends, in the adjudicatory process, the courts are required to decide about the right, liability, or disability. It is asserted by the one party and denied by the other party. It naturally requires some method, some means, some process, so as to arrive at the truth. If we travel back to the medieval period in Europe, there were strange methods of determination of guilt or proving right or wrong. And they were usually called trial by ordeal. So there was ordeal by water, ordeal by fire, and also ordeal by combat. In ordeal by water, the person who is having an accusation against him shall be thrown into the pond of water. And if the body sinks, then the inference had been that the God has accepted him and he is innocent. But if the body floated, then he was held guilty because the God has not accepted him. Likewise, in trial by fire, the accused was asked to go 9 steps, holding a red-hot iron bar. Naturally, he will receive burn injuries, and if the injuries healed within 3 days, then he was held to be innocent. And if the injuries, didn't heal, then he was held to be guilty. And in this ordeal by combat, so the accused and the accuser will fight with each other, maybe by revolver, maybe by sword, or maybe by fist. And whoever wins shall be treated as the person on the right side, and whoever loses was held to be on the wrong side. So naturally, these methods of determining the right and wrong were quite strange, crude, and instead of delivering justice, such methods perpetuated injustice. So in course of time, it was thought that this process of determination of truth or falsehood should be based on certain rules consistent with reason, logic, and common sense. And this thinking gave rise to the growth and development of law of evidence. When Britishers came here and they have established a hold, then they thought of enacting laws including IPC, criminal procedure, and evidence. The task of enacting law of evidence was assigned to Stephen. It was sometimes in 1871, and he submitted the draft, which was approved by the 13-member Judicial Council, and thereafter it was brought into force with effect from 1st of September 1872. So that way we can find the genesis of the Indian Evidence Act 1872, and for pretty long time, we can say for 150 years plus, this enactment served the Indian judicial system in a beautiful manner. And as a matter of fact, this law was regarded as a very, perfect law. But what happens that the society is organic in its nature. The needs of the society and the persons therein keep on growing and developing. That way, we can see that the Evidence Act of 1872 came to be amended as many as 26 times till the last amendment was carried out in 2019. This simply shows that growth and development of law in accordance with the needs of the society is necessary. In this regard, I remember a beautiful statement from a judgment rendered by the apex court of our country, that is Padampat Singhania, Sugar Mills versus the State of UP. And in that case, Justice P.N. Bhagwati, he observed that law is not a mausoleum. मकबरा नहीं है कि इस पे फूल चढ़ाते जाएं. Law is not a mausoleum. It is not an antique to be taken down, dusted, and admired and put back on the shelf. Rather, it is a vast and vigorous tree having its roots in history and time to time giving out new sprouts, as well as occasionally dropping out dead wood. The statement further goes in the manner that law must be consistent with the needs of the society, and if there is estrangement between law and society, then law will cease to have legitimacy. So that way we find that multiple amendments in the Indian Evidence Act made it a document which was having multiple patches at different places right from beginning to the end. Apart that, this was lagging behind what the needs of the society, and we can see that in past 25 years or so, the ICT has almost covered our entire, aspects of life. We start our day with a smartphone. We see that what are the messages, and we go to the bed after just again having a look at our smartphone. That is the degree to which the technology, ICT, has surrounded us, has pervaded our all the activities of life. So this was the one reason which persuaded the parliament to enact a new law which can deal with the challenges of the time. Particularly, you see that there are cases of hacking, there are cases of cyber frauds, and on civil sides, even the agreements and contracts are being, you see, concluded by sitting between in two distant places by ICT mode. So therefore, it was necessary to bring the law in sync with the technology. Another reason which I consider is very important and which prevailed upon the legislature to enact this new law, that has been to get rid of the clouds which we found in the Act of 1872. Ultimately, it was given by Britishers who were ruling us at that time, and they inserted so many provisions in this act which have nothing to do with the courts in India or with the evidence which is required before the courts in India. Rather, they signified the old, you see, footprints of the colonial time. The third important factor which persuaded the parliament to legislate this law appears to be that the Indian Evidence Act 1872, of course, a wonderful piece of evidence, was lacking in the direction, which direction to go. If we see the long title of the Act of 1872, it says that it is to codify, consolidate, and amend the law relating to evidence. But now, in the Bhartiya Sakshya Adhiniyam 2023, the long title of the Act provides a specific direction to us that it is codified and consolidated with the aim of providing rules and principles of fair trial. Now, this fair trial aspect, which basically just got a momentum after Second World War, we find its reference in many of the international covenants and instruments, but surprisingly, none of the Indian enactment talked about fair trial. So I think it was apt and very, you see, necessary to provide a direction that ultimately what the courts are required to do and how they should conduct. So these three reasons indeed persuaded the parliament to bring this new legislation. Apart that, certain structural and cosmetic improvements have also been made, and that way we have the new act. Now, I would like to discuss the changes that have been introduced by this new legislation in three parts. In the first part, I will discuss about the architectural changes which are of formal nature and may not have any substantive impact. It is simply like that on which side there should be the door of the house, on which side we should have the window, and if window, then how many windows. It's simply like that. So these are the cosmetic changes. But then when it comes to substantive changes, then we will discuss them, that substantive changes for information and communication technology. How the legislature has tried to bring the law of evidence in sync with the current issues and challenges with regard to the information and communication technology. Then we will also try to analyze that what are the provisions which ultimately give a distinct direction with regard to the concept of fair trial. Now, when we come to the concept of fair trial, then we have to understand that for many, many years, whenever we would talk about fair trial, it was considered to be the fairness to be given to the accused right from the commencement of the inquiry or investigation till the conclusion of the trial and even after the trial at appellate stage. But as laid down by the Supreme Court in the famous case of Jaira Habibullah Sheikh, 2006, this fair trial is not confined only to the accused. The concept of fair trial includes within itself the fairness to victim, the fairness to prosecution, fairness to society, and as well fairness to the accused. So that way, in my humble view, the legislature has tried something very special to introduce the elements of fairness to different stakeholders of the system in different manners. We will discuss about it as and when we come to that. First, we discuss the formal changes or structural changes or cosmetic changes. Now we see that the Act of 1872 had 3 parts, 11 chapters and 167 sections. Part 1 comprised of Chapter 1 preliminary and Chapter 2 relevancy. Part 2 dealt with the aspect of proof, having Chapter 3, 4, 5 and 6, while Part 3 comprised of 5 chapters, 7, 8, 9, 10 and 11. Now what has been done, the Part 1, which had 2 chapters, has been divided into 2 parts. Now the preliminary chapter falls in Part 1 and the relevancy falls in Part 2. So that way, first 2 chapters, they are Part 1 and Part 2. The cascading effect of this division has been that Part 2 of the old Act of 1872 has become Part 3, comprising of those very chapters. Chapter 3 on facts need not be proved, Chapter 4 of oral evidence, Chapter 5 of documentary evidence, and Chapter 6 exclusion of oral evidence with regard to documentary evidence. These the chapters now fall in Part 3, and again the cascading effect is found in Part 4, which was not there because the Part 3 comprises of Chapter 3, 4, 5, 6. So the remaining chapters 7, 8, 9, 10 and 11, they fall in Part 4, including a new chapter, that is Chapter 12, dealing with the savings and repeat. That way we can say that the total structure of the new Act has not been changed substantially. There are no, simply some effects, cascading effects are there, and now instead of 3 parts, there are 4 parts. But then the scheme of the chapters remains the same, nothing has been changed. When we come to the other formal and cosmetic changes, then firstly, we find that in the Act of 1872, we will find different expressions for the person who can appear on behalf of a litigant in the court. Sometimes it was barrister, in some other provisions it was pleader, it was also attorney. Therefore, all these expressions have now been replaced by one expression, that is advocate, and which is acknowledged in the Advocates Act 1960. So that is really a good change, because for a person who is just starting a study of law of evidence, it would have been a very difficult question that ultimately why such different expressions are used at different places. Is there any reason behind it? Of course, there was no reason. Therefore, we find that now single expression replaces them all. Another thing, very simple, that Madras now stands for Chennai word stands for Madras, Mumbai stands for Bombay, and Kolkata stands for Calcutta. So such type of words have also been replaced by new expressions, and that gives that flavor of that it is with the current times. Law is running with the current times. Then we see that in the definition clause in the Act of 1872, there was definition of India. Now see, what is India need not be defined in a statute like IPC or the Evidence Act, because our constitution very much expresses what is India. But when the Evidence Act of 1872 was enacted, there was no constitution. Therefore, the framers thought it appropriate to define what is India, but now this definition has been left out. It was considered totally unnecessary. Then, when we go to section 1 of the new act, we see two changes, and one is with regard to the territorial application of the act. In the Act of 1872, it was provided in section 1 that the act extends throughout the territories of India. But in the new section, this expression is particularly missing. What does it mean? Whether it has been deliberate or it is simply a slip of the legislature. As I understand, it is not a slip. It is well thought out decision, because the Evidence Act as it stands today of 2023 will have to deal with so many issues and disputes which may have extraterritorial involvement. A person sitting in any other country can hack the website. Recently, it was done in the case of M's website. And then there are day-to-day we see that the offenses, cyber frauds and cyber offenses are being committed by persons who are sitting far away from the territories of India. So in that way, if we continue with the expression that it extends throughout to the territories of India, then definitely there could have been a technical objection that the offense was committed somewhere in other place and this act is not applicable. So to do away with such type of objection, that expression has been left out. Then we see that in the Act of 1872, we had definition clause section 3 as well as section 4. Section 4 defined may presume, shall presume, and conclusive proof. Usually we see that in any enactment, there is always one definition clause. So now that minor error has been rectified by merging section 3 and 4 definition clause of the old act into section 2, which is the definition clause in the Act of 2023. Apart that, we see that when we proceed further, I am simply talking about the formal changes which doesn't go to the substantive issues. simply basically making arrangements better. And one thing that has been done, that is in the relevancy chapter, that earlier we had section 24, that confession obtained by inducement, threat, or promise is inadmissible in evidence. Now, this was the rule, and we will find that section 28 and 29 of the old Evidence Act of 1872, they constituted the exception to the rule contained in section 24. So naturally, the exception should be along with the rule. So now section 28 and 29, which constituted exception to section 24, have been put with the new section 22. 22 is the rule, and then proviso 1 and proviso 2 are the exceptions in the shape of old section 28 and 29. That is again a welcome change, because it introduces clarity, because one need not go to different places. Then another such thing we find again in this chapter part relating to confession. Now, section 25 prescribed that confession made to police officer is inadmissible. Section 26 further provided that confession made by an accused in police custody is also inadmissible in evidence. Then section 27 provided an exception to the rule contained in section 25 and 26. And this exception has been in the form that the statement made by an accused person in police custody to a police officer leading to the discovery of a fact, that will be admissible to that extent. So we can simply say that 27 is an exception to the rule contained in section 25 and 26. So now these three sections have been put together, and the new incarnation is section 23. So 23, the rule is provided 23.1, 23.2, and the exception is provided in the shape of proviso, and that is section 27 of the old Act. So that way, this putting together these three provisions in one section, in my considered opinion, introduces clarity, and it gives little more, you see, specific idea about that what is rule and what is exception. Then when we proceed further, then we say that in the Act of 1872, section 88 provided with regard to the presumptions relating to the correctness of the telegraphic messages. Presumption that whatever was sent has been received in that very sense. Now, we do not have telegrams nowadays. We stopped having telegrams long back. It has been replaced by different type of emails, SMS, and WhatsApp messages. So that section was, as a matter of fact, redundant, and that has been left out in the new legislation. If you further go into the provisions of the Act, then we'll find that there was section 113 of Act of 1872. It provided proof of cession of the territory. Now, if we go through section 113 of the old Act, then we will see that it provided that if there is a cession of the British India territory, part of the territory, to a princely state, then how it will be proved. And this cession of the territory from the British India territory to the princely state territory could have been carried out under the Act, the Government of India Act 1935. So now all those things are no more relevant and no more existing. There is nothing like British India territory. There is nothing like princely estates, and therefore this section 113 was totally redundant, and therefore it has been left out. Then one more provision which has long been there on the statute book without any utility, just like an appendix, has been section 166, which provided with regard to the, jury trial. Now, jury trial has long been just absent from the criminal justice system of India, and people remember that it was K.M. Nanavati's case, which ultimately proved that such jury trial is not relevant and not, conductive to the determination of guilt, particularly in the India. So that way, this provision has also been left out. And all these, of course, these are formal changes, but then these were the changes which make the new enactment more compact, more consistent, and more clear as regards the rules and principles of evidence. Now, this is part one. Now we enter to part two. In part two, we would like to consider that how we say that the Act of 2023 has been a very serious attempt to get rid of the colonial clouds in the law of evidence or the colonial provisions. In this regard, first of all, we can refer to Section 57 of the Act of 1872. The new incarnation of Section 57 happens to be Section 52. Now, this Section 57 provided by and large, clause 2, clause 3, clause 4, clause 5, and clause 6. All these clauses, they were dealing with what the courts are required to take judicial notice. Basically, old Section 57 deals with facts of which court must take judicial notice. And in Section 57, clause 2, clause 3, clause 4, clause 5, and clause, all they dealt with the whatever is being done by the Parliament of the United Kingdom or the courts of the United Kingdom. Clause 2 provided that all public acts passed or hereafter to be passed by the Parliament of United Kingdom and all local and personal acts directed by Parliament of United Kingdom to be judicially noticed. Why? Then proceedings of the Parliament of the United Kingdom to be judicially noticed. Again, why? Then accession and the sign manual of the sovereign for the timing of the United Kingdom of Great Britain and Ireland has to be judicially noticed. Then clause 6, all seals of which English courts take judicial notice were required to be taken judicial notice by the courts in India. So all these provisions, as a matter of fact, reflected the colonial impact and effect of these provisions, and they have been done away. Then, in the like manner, we had old section 74, and the new section is also 74, and it provided with regard to what are the public documents, and it included the documents of the Commonwealth. So now the documents relating to the Commonwealth has totally become irrelevant for the sovereign country like India, and therefore that has been left out. Again, if we go to old section 78, this section dealt with the proof of other official documents. And clause 3 of this section 78 provided that proclamations, orders, or regulations issued by Her Majesty or by Privy Council or by any department of Her Majesty's government by copies or extracts contained in the London Gazette. They can be proved by copies or extracts contained in the London Gazette or purporting to be printed by the Queen's printer. So these provisions really, they had the colonial flavor, and unless such provisions are there on reciprocal basis, they need not be retained in the law. And that's why the legislature removed all these provisions. And in this series, we also find two important provisions that have been, one is section 82 old. Now this section 82 old exclusively dealt with the presumptions as to the documents admissible in England without proof of seal or signature. So why there should be a presumption about a document which is admissible in England without proof of seal or signature? If there is no reciprocal presumption with regard to the Indian documents in the British courts. So that way we see that many changes have been made simply to ensure that all these colonial provisions are not there. This is also with regard to the old section 81, which provided that the court shall presume the genuineness of every document purporting to be the London Gazette or any official gazette or the government gazette of any colony, dependency of possession of the British Crown, or to be a newspaper or journal, or to be a copy of the private act of Parliament of the United Kingdom printed by the Queen's printer. So all these provisions, which were clearly of colonial era and of were having colonial flavor, they have been systematically removed, and that way we can say that our new act is now free from any colonial clouds or any colonial impact, and that way we can have more the spirit of Indianness in the Bhartiya Sakshya Adhiniyam 2023, because it is in accordance with the aspirations of the people of India. Now, in the next part, we will discuss the provisions with regard to the fair trial. Now, fair trial concept, as I discussed earlier, that is with regard to a broad concept where all the stakeholders in the process of justice delivery system are treated with some sort of fairness and care. Earlier, it was confined by and large to the fairness to be fairness to the accused. But then we never just had anything that there should be fairness to the victim, fairness with the prosecution, fairness with the society. Now, with that celebrated judgment by the Honorable Apex Court in the case of Jahira Habibullah Sheikh, now this concept has gone a sea change. And now fairness or a fair trial means fair trial to victim, to the accused, to the prosecution, as well as to the society. Now, what are the changes that have been introduced in the Act of 23 with regard to this element of fairness to all the stakeholders of the system? Now, we can start from the part 1, chapter 1, section. If you remember, old Act in section 1 provided that the Act will extend to the territories of India, but it will not apply to court martials held under the Army Act, under the Air Force Act, and under the Navy Act. Meaning thereby that in thousands of trials which are conducted by way of court martial, the persons were not able to use the variety and various provisions of the law of evidence for their defense. That was definitely unfair. It was by the Britishers to enforce discipline, and now apart from the discipline, fairness is also necessary. So therefore, the new Act excludes this particular expression that the law of evidence will not apply to court martials held under the Army Act or the Navy Act or the Air Force. So this enhances the fairness element in the Evidence Act. Then we'll find that in section 2(1)(f), section 2(1)(f) of the new act defines fact. Now, two very important things are there with regard to the definition. Firstly, that the legislature has tried to use gender neutral phraseology. So in a number of illustrations which were given under section 2(1)(f), the man has been replaced by person. Just like in the cricket, the batsman has been replaced by batter. So we are just talking about the gender justice, gender equality, but what has been essential is that gender neutrality should also be there. And Honorable the Supreme Court of India, almost I think a couple of years back, circulated a glossary with regard to the words which will be used by the courts and which are of gender neutral nature. So that way we can say that this provision of just replacing man by person introduces fairness to the female under the act. Then another aspect with regard to this fact I will discuss later on and in the next part. Prior to that, we'll go to the section 22. I have already discussed the structural change in 22 because 22 is the new incarnation of old section 24, 28 and 29 that dealt with the procurement of confession by inducement, threat or promise. So now the element of fairness that has been added is that not only the confession obtained by inducement, threat and promise is inadmissible, but even if the confession is obtained by a coercion, then again it is inadmissible. So we can say that the scope of section 22, old section 24 has been enhanced, and now even if the confession is obtained through coercion, it will be admissible. Definitely it enhances fairness for the accused. Then we will see that we had old section 30 in the Evidence Act. It provided with regard to use of confessional statement made by an accused against an co-accused in the same trial. Now we see that in the new enactments, particularly the Nagrik Suraksha Sanhita 2023, a new concept has been added, and that is with regard to the trial in absentia. We know that almost 30 to 35 cases before the trial courts are held up because one or the other accused is absconding from the trial, and this is not something accidental that the accused remains absent during the trial. It is, very planned affair. It is a systematic, well-planned manipulation to derail and frustrate the trial. And that ultimately resulted that if the 35% or 30% criminal cases are held up or are put into cells simply because the accused is not available to face the trial, then it weakens the criminal justice system. Bangladesh has long ago introduced trial in absentia. It is there. And therefore, we can say that I have interacted with the judges of the Bangladesh in some of the conferences, And their system in that regard is more sturdy and more strong. Now, this concept of trial in absentia, which I also, recommended as chairman of the Madhya Pradesh Law Commission in one of my reports submitted as criminal justice reforms on criminal justice reforms, that there should be trial in absentia. And now this concept has been brought into our criminal justice system, and it can be argued that it is unfair to the accused. But as a matter of fact, it is not unfair to the accused, because the accused is trying to derail the process of justice delivery by his own act and conduct. Therefore, he cannot say that the trial should not be conducted against in his absence. On the contrary, this particular provision provides fairness to the victim, fairness to the prosecution, and fairness to the society, because now there will be a trial even in absence of the accused who is absconding, and then there will be adjustment of acquittal or conviction, whatever it may be, then followed by sentence. So this will force such type of to join the trial. So that way we can say that this provision, which now the old section 30 is now new incarnation, is section 24, and it says that confession made by who accused by an accused can be used against the accused against whom trial in absentia is being conducted. So that way it enhances the fairness. Then the next provision which we find in that chapter of relevancy. Earlier it was there in section 41 of the Act of 1872, that judgments rendered by a court exercising matrimonial, insolvency, probate or admiralty jurisdiction are relevant in other matters. These judgments are considered to be judgment in rem, and therefore, apart from being that usually the judgments are relevant between the parties or their successors, but then these are the judgments in rem. And now you see there has been a new phenomena that has emerged in India, that the insolvency jurisdiction is now being exercised by tribunals also. There is one tribunal that is under the Insolvency Code of 2016, and the adjudicating authority, that is the National Law Company Tribunal, that has the jurisdiction to declare the company or the party as insolvent. And therefore, the new provision, which is the section 35, says that judgments rendered by court or tribunal exercising this jurisdiction shall be read. So again, I think that it enhances fairness. The next provision we can look at, that is section 39 new, and that is incarnation of old section 45. Now section 45 dealt with that in what cases the opinion of expert is relevant. And as per section 45, there were only 5 areas where the opinion of the expert was considered to be relevant. These areas are opinion with regard to foreign law, science, arts, fingerprinting, and handwriting. So it was only in these 5 areas that the court can take help of an expert. But now see, with the current advancement of business, commerce, and other activities, there are so many other areas where the court may need the assistance of an expert to form to arrive at a decision, just and fair decision. So the new provision that has been brought in place of section 45 old, that is section 39, and it says that opinion of a person in any other field, expert in any other field, shall also be relevant. So there may be a case which is not covered by those 5 areas of foreign law, art, science, handwriting, and fingerprinting, but still it is a field of an expert. So that way, you see, the opinion of the expert shall be relevant and admissible. I think that it will help the courts in resolving very complicated issues which cannot otherwise be dealt with without the assistance of the expert. So again, in my view, this is a provision which enhances fairness in the process. Then, if we proceed further, we see that section 58, new, that is the incarnation of old 63, it makes oral admissions as well as written admissions admissible as secondary evidence. This is an addition. Earlier it was not there. Now, if there is a oral evidence admission or a written admission, then that will be admissible as secondary evidence, and definitely it will help the parties in just procuring justice. It will enhance fairness. Now, we just when we proceed further, traveling from chapter to chapter and section to section, there is one chapter, estoppel. Now, in the chapter relating to estoppel, there is a provision, that is old section 116. And it said that the tenant shall be estopped from denying the ownership of the landlord during the continuance of the tenancy. So that means that if the tenancy stands determined or terminated, then tenant can have the right to deny the title of the landlord. So that was indeed little unfair for the landlord. So this provision has been modified, and now it says that a tenant shall be stopped from denying the title of the landlord during continuance of the tenancy and even determination, even after the determination of the tenancy. So this provision again enhances fairness in the process of justice administration. Then another provision which I consider is fair to a particular section of the persons which appear before the court as witnesses. Earlier, there was in section 118, there was reference to lunatic as a witness. Now, the Lunacy Act has long been repealed, and this word lunatic is considered to be derogatory. In Hindi, it means vikshipt. So now this expression lunatic has been replaced by mental illness. So a person suffering from mental illness instead of a person who is lunatic. So this is definitely a fair provision with regard to that person who is appearing as a witness and has some or the other type of mental health problem. Then the last provision in the Evidence Act, which introduces element of fairness, is new section 168, and that is the incarnation of old section 165. Now, this old 165 provided the power of the judge to put questions to a witness, and it was in the shape that the judge, when he pleases, can put any question at any time to any person in any form, relevant or irrelevant. Now, two things were little unfair. One, that it was dependent on the pleasure of the judge to put the question. In the judicial determination or adjudication, there is nothing like pleasure. It is whether as per law it is necessary. So now the pleasures has been replaced by if the judge considers necessary. And if the judge considers necessary, then definitely it should be for certain reasons. So then it introduces that fairness. And apart that, giving authority to the judge to put even irrelevant questions, while entire law of evidence deals with relevancy and admissibility, was to my mind, that was definitely unfair. So that has been removed. Now that expression relevant or irrelevant has been removed. Now the judge can put any question if he considers it necessary from any person at any time in any manner. So now it is up to the judge, and definitely giving the total approach of the law of evidence based on relevancy and admissibility, the judge will not just go to ask a question which is irrelevant. So friends, this is all about what we can say, that enhancing the element of fairness in the Bhartiya Sakshya Adhiniyam. And this is definitely something which will have far-reaching impact, and it will give a boost to the approach which the court should have in deciding the cases by adhering to the principle of fairness. Now, last and concluding part, I would like to deal with the changes that has been introduced with regard to the ICT. Now, friends, ICT has enabled us by making quick messages, by storing vast material in the digital and electronic form, quickly access and approach the systems by electronic methods. So basically, now if we just carefully examine, many of our activities are being in sync with the ICT. We do many things every day, basically sending WhatsApp messages, sending emails, storing a video, storing a voice message, and concluding an agreement through the help of the ICT. These are all the things. Apart from, we are just aware that so many crimes are being committed with the misuse of the ICT. So now the legislature has taken, due cognizance of all these sectors. The IT Act of 2000, of course, provided certain provisions and particularly in the shape of section 65 and 65A and 65B with regard to the admissibility of the digital or electronic evidence. But then we know that these provisions were considered totally inadequate. It can be understood by the fact that from 2000 to 2020, our apex court was itself struggling with the issue that what is primary evidence and what is secondary evidence when it comes to electronic evidence. And we have different decisions during that period. Particularly, we know Navjot Sandhu's case, one interpretation was given. Then in P.K. Basir's case, that interpretation was changed. And then finally, we have that Pandit Rao Khodkar's case, in which again the Supreme Court came out with a different interpretation. So that way it was necessary to clarify the things in a systematic manner, that what is primary, what is secondary, and how to prove the digital or the electronic record. Now this has been done in a systematic manner. First, we go to the definition part. Two definitions, first of document contained in section 2(1)(d). Now the document, apart from the conventional documents, includes any record, anything which has been recorded in any manner on any object. So now anything recorded in any manner on any object, it gives a very, you see, wide amplitude to the expression document. And given the illustration that has been appended, illustration 6 to section 21D, now it includes emails, other information is stored in our communication device. It may be our laptop, desktop, or system, or even clouds, etc., etc. So that way, the scope of the document has been enhanced multiple times. Apart that, though we started recording statements online, in some cases, pursuant to the decisions rendered by Honorable the Apex Court of the country, but still there was no statutory support with regard to that. Now, the definition of evidence as contained in section 21E clearly provides that evidence includes statement recorded in electronic form. So now, whatever we do, recording the statement or recording the, you see, statement of the expert sitting at a faraway place. Sometimes it may be a police officer not able to come to the court because he has retired, so he can depose online, and that is, you see, quite in accordance with the statutory framework. Now, with these two definitions, we jump to the chapter relating to primary and secondary evidence. So now, in primary evidence, earlier we have three clauses: original document, documents which has been prepared in counterparts, documents which are prepared simultaneously with the mechanical process. They are all primary documents. But then now clause 4, 5, 6, and 7, they have been introduced, and that is old section 62. Now the new incarnation is section 57, and these 4, you see, clauses which has been added in the definition of primary evidence, they are exhaustive enough to bring within its fold all type of evidence that is electronic or digital. You can just have how it says, how it reads. It says, let us have that where an electronic explanation 4 to the new section 57, where an electronic or digital record is created or stored, and such storage occurs simultaneously or sequentially in multiple files, each such file is primary evidence. Then, where an electronic or digital record is produced from proper custody, such electronic or digital record is primary evidence unless it is disputed. Again, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of such stored recording is primary evidence. Then explanation 7, where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. So that way we see that the scope of this digital or electronic record in the shape of primary evidence has been made very quite exhaustive. If we go by this explanation 4, 5, 6, 7, then it hardly there will be any electronic or digital record which will stand out not as document or admissible as electronic or digital record. Then, to further make the things clear and to put a safeguard against the rejection of the digital or electronic record, a new provision has been inserted in the shape of section 61. And section 61 provides that the evidence relating to digital or electronic record, it says, I read it, nothing in this Adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall, subject to section 63, have the same legal effect, validity, and enforceability as other documents. So to do away with all type of technical objections, this is an overriding provision. Then section 62 is the new incarnation of exactly the same provision which we found earlier in section 65A, and section 63 replaces old section 65B. Now, section 63, just like old section 65B, provided the mode and manner in which a digital or electronic record can be proved. Now, it provided that it was in the ordinary course being used to fed that type of information which is being given before the court, to store that type of communication, that it was running in a proper condition and was not out of order, or if it was not in a proper condition, then such situation does not affect the integrity of the information stored in the computer system or the device. So all these things were required to be proved before the court in order to get the digital or electronic record proved before the court. Now, the old section 65B provided the necessity of a certificate to be given by the person who desires the proof and admissibility of the digital or electronic. But then there was no format of the certificate. In the new code of 2023, a schedule is there, and in schedule, two certificates, pro forma certificates, have been given. One certificate has to be given by the person who is in possession of the device or the storage or whatever computer, laptop, or anything like that, including our smartphones. And the another certificate is required to be furnished, that is a pro forma B certificate by an expert who has examined electronic or digital record with regard to anything which need to be proved before a court. So now these pro formas are very exhaustive. They just very important information, all relevant information with regard to the device and with regard to the storage, etc., has to be given as per these two certificates. So there can be very, minimal occasions when the digital or electronic record can be refused to be admitted unless it is lacking in the support provided in the pro forma A and pro forma B certificate. So that way we see that the legislature, in order to ensure that digital or electronic record is allowed to be adduced by way of evidence before the court, has taken all the precautions. All the provisions have been made that there is no objection with regard to their admissibility, and if the procedure prescribed under the new section 63, that is replacement of section 65B of the old, if that is followed, then definitely the evidence will be available before the court for consideration. So friends, this much was with regard to the digital evidence and digital record, that the changes brought by the new legislation to ensure their admissibility and acceptance. And one more thing which can be noticed here is the language of section 63. Now, we have the definition of document in section 2(1)(d). Apart that, some deeming fiction has been provided in section 63, and I read it out. Notwithstanding anything contained in this adnium, any information contained in an electronic record which is printed on paper. So any printout of any digital or electronic record falls within the definition of document. It goes further. which is printed on paper, stored, recorded, or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device, or otherwise stored, recorded, or copied in any electronic form, shall be deemed to be a document if the conditions mentioned in this section are satisfied in relation to the information and the computer in question. So that way, a deeming fiction is there that even a printout from the device or from the computer or from the laptop shall be considered to be a document. Apart that, now there are various, you see, whenever we see something by way of this images, etc., they are automatically uploaded to the Google Cloud. So now if something is stored in the Google Cloud, we have deleted the photo or the information from our device, but then still it is there in the Google Cloud because we have not deleted from there. So that you see information or the image or the whatever it is shall be admissible as document. Apart that, whenever we store anything in our computer and device, then a temporary file is simultaneously created. We delete the main file, but this temporary file is still in the device. It can be retrieved by an expert. So that again is a digital or electronic file. So that way we see that the legislature has tried to put all the things in Bhartiya Sakshya Adhiniyam to address the problems with regard to the proof and admissibility of the digital or electronic evidence, as well as the controversy with regard to what is primary evidence and what is secondary evidence. So, friends, this much I wanted to share with you with regard to the Bhartiya Sakshya Adhiniyam 2023. The legislature has discharged its duty. Now it is our duty as judges, as lawyers, that we, with all the ways, we apply the provisions of the new act in such a manner that we address the problems with regard to the digital evidence, electronic evidence, and at the same time, the element of fairness is apparent in each and every stage in all the proceedings of the court. Thank you very much for listening me online, again with the help of ICT with regard to this new act. There are certain gray areas, and of course they will come before the honorable courts, constitutional courts for determination, but prior thereto they will come before the trial courts. And one is that the certification under section 63. So now section 63 says that for admissibility, there should be a certificate in pro forma A along with pro forma B. Certificate in pro forma A is by a person who is having the custody of the device, and pro forma B is by an expert. There may be a case, a bank is submitting the statement. Now there is no dispute with regard to the statement. So what is the need of certificate B? Only certificate A is sufficient. Okay. The bank manages an expert and he is providing the certificate B. Now take another case. There is a device, communication device, that is seized from the possession of the accused. Now certain information is there in that device. Now whether the accused can be forced to give a certificate against himself that all the information contained in the device is true to my knowledge, will it not amount to violation of Article 20 of the Constitution of India? And will it not be a situation where an accused is compelled to depose against himself? So I think that is an anomaly, apparent anomaly in the language of section 63. It should have been in the form that the evidence shall be admitted if a certificate in pro forma A or pro forma B or pro forma A and B as the case requires. Just as there may be a situation where both the certificates can be obtained, but when a criminal case is concerned, at least no accused person can be compelled to certify that whatever is there in his communication device is true and correct. So these are few anomalies here and there, and they will be addressed in course of time. Always there should be a purposive interpretation. The effort should be that all these provisions are just giving true application and interpretation. And apart from that, that we can address the problems and challenges posed by the ICT. Thank you very much. I would also like to express my gratitude and thanks to Vikas Chakarji, which always gives me an opportunity to connect with many, interested persons, viewers, listeners with regard to all these legal issues. And he is doing indeed a very great job by just devoting time and resources to this activity. Thank you, Vikas, very much. Thank you, all the listeners.
Thank you, sir. As usual, I can say some have expressed the word expression as narrative, but I will say the way you have weaved the entire session in 1 hour, 15 minutes, the way you had said, firstly, it shows how much you have the time management to express in the right way. To say that you had said that it will take around 75 minutes, and as it's by the clock, exactly 75 minutes. That shows the meticulous planning and the way you have taken across. And I will not take the names, but everybody on the chat box, on the Zoom, as well as on the YouTube.
Vikas, there are 2 questions you have sent to me.
Yes, sir, on the WhatsApp.
I come to those questions. The one is admissibility of audio call recorded on mobile, whether primary evidence. So in view of section 52 relating to primary evidence, all such recordings shall fall within the category of primary evidence. Section that provision, the explanation 4, 5, 6, and 7 are exhaustive enough to include any form of digital or electronic record being treated as primary evidence. And if you print out, you see when it is the call recording, so there can be no paper printout. What will be produced before the court can be a copy of such recording, and this copy of such recording shall also be treated as primary evidence for the purpose of the evidence. And that way, this call recording will fall within the category of primary evidence. The second question was whether documents received under RTI are admissible in evidence during the trial. Now, this question basically falls that whether it is a certified copy which is of public record which is admissible under law as evidence. So if such a copy of that received from the under RTI from any office is fulfilling the conditions laid down for admissibility of certified copy of a public record, then of course it will be admissible. Now, what are the conditions required for admissibility of a certified copy of a public record? It is that first it is certified that it is certified true copy, then it bears the signatures of the person who is having the possession of the record, and if he is allowed to use the seal, then it bears the seal of that person. If these 3 conditions are fulfilled, then I don't think that a document which is received under the RTI can be held to be inadmissible. And secondly, the receptiveness of the court should be there. Let it be admitted, discussed, and let the Constitutional Court give an opinion about it. So that way we need to do. Thank you very much, Vikas. Any other question? I would be happy to answer. आपकी आवाज नहीं आ रही है. Are you muted?
Yes, sir.
Any other question? I would be happy to.
Thank you, sir. Thank you. Thank you.
Okay. Thank you very much.
Thank you.
All the best.
Thank you, sir.